This is Dr. Owais Shaikh, and um, this webinar is regarding the regulations, different regulations of geographical indications that we have on international level, on the European level, and also we look at the Pakistani law, which was promulgated back in 2020 as a case in point. Um, Back in the year 2020, we also organized a webinar on Basmati as a GI, and at that time, um, the application for Basmati from India was filed in the EU, and in that webinar, we actually looked into the different options that Pakistan had with regard to that application. So hopefully, we will have some light shed on that as well from Mohammed Ismail, who is representing Intellectual Property Organization of Pakistan. Um, so let's formally start the session. My name is Dr. Owais Shaikh, and I'm an associate professor at Shaheed Zulfiqar Ali Bhutto University of Law, Karachi. And with us today are Dr. Andrea Zappalaglio, and I hope that I'm pronouncing your name right. Um, he's a lecturer at the University of Sheffield, and I'm really happy that he has joined this webinar. In fact, this is my first face-to-face meeting with him, and I have followed him on different social media especially with regard to his book on EU GI regulations. We also have Sanaz Farahzadi with us. She is actually an international lawyer. She's a very, how should I say, keen GI rights and women rights activist at the same time. And actually, we also got in touch post the Basmati GI webinar. And I'm so happy that she has been able to take time out for this webinar as well. Mohammed Ismail is a very dear friend. We've known each other for more than 18 years. We started working together at the IP office. And since then, we have remained in close contact. And we almost meet, even though he's in Islamabad and I'm Karachi, but we kind of talk every second week and we get to meet at least once in 6 months. And Ismail is basically heading the section on geographical indications, traditional knowledge, genetic resources, and folklore. So welcome, Ismail. Thank you for accepting my request. And we also have a very special guest with us today, Salman Khalid Saab, who is the second secretary at the Permanent Mission of Pakistan to the UN. I also came across Khalid Saab recently, I think two weeks back, and meeting him was one of the let's say highlights of the recently concluded ComsTech training course on intellectual property management in Islamabad 2 weeks back, where Sanaz was also my co-trainer. And I was so happy to see someone in the mission who is so keen and eager about intellectual property. And he has been representing Pakistan at different UN agencies and the Pakistani interests in intellectual property. So I would also like, before we actually formally go into the webinar itself, I would like to request Salman Khalid Saab to take a couple of minutes and introduce the mission's work with regard to IP in Geneva and how. So what are the functions that you're performing in Geneva representing Pakistan? The floor is yours. Thank you.
Thank you very much, Dr. Vaisab. And this is true. I do not know you for a long time, but what I know is that you are too generous when it comes to extending good words about your fellow colleagues. But thank you very much for providing the opportunity. And in fact, I cannot tell you how glad we are as a government entity representing Pakistan in Geneva. We are not. I cannot tell you uh, how good it feels to know that uh, uh, Shaheed Zulfiqar Ali Bhutto University and you yourself are taking these very useful and timely initiatives. Uh, I will not take a very long time to allow our distinguished speakers to talk about this very important topic. I'll just highlight a couple of points with regard to the mission. Since the enactment of the GI Act in 2020, we have been trying to play our part to sensitize our national stakeholders on the importance of this issue. I think it's very clear to me and to all of us that IP in general and GIs in particular, they are kind of a gray area when it comes to their basic understanding, especially on geographical indications. I think uh, now the understanding in the government functionaries, at least in Ministry of Commerce, in IPO is working very hard these days. They already have Mr. Ismail would apprise more on this. They're working day and night to ensure that that GIs in Pakistan they are protected as soon as possible. But I think the real need for awareness raising is among the end users of the protected GIs, which are exporters, growers. uh, so I think this is one area. So we are very happy. These are the kind of interactions that we need. With IPO Pakistan, we also organized a small event on Sargoda Kinu, which is also a notified GI in Pakistan a few months ago. Uh, I will not go into the details, but we have two projects in the pipeline. One of the Under one of the project, we'll have a 2 to 3 day workshop later this year, and the idea is to explain the economic potential of the geographical indications for Pakistan. Secondly, regulation, in fact, is the first and fundamental and necessary step. But but at the same time, I would like to take the liberty to say that this is the first step, and this is where it all starts. uh, One of the projects that I was referring to earlier, it actually talks about the post-registry utilization and commercialization of geographical indications. Of course, the registration offers protection. It builds the necessary administrative infrastructure for quality maintenance and things like that. But at the end of the day, the growers, the exporters, they must be able to utilize the geographical indications to market their products. And this is where I would like to emphasize more that probably we need to bring in stakeholders. Of course, I understand this is just a start, but at the same time, we have a robust startup ecosystem. SMEs are, being supported by the government. We have national incubation centers. I mean, we also need to take this debate of GIs to those stakeholders so that the SMEs, especially, they can utilize the GIs. Thirdly, I would like to state that one of the things that that need more coordinated and concentrated effort is branding. I feel as a country we lack a lot in branding. I mean, we have too much to offer. You look at tourism, you look at mountains, you look at other touristic places. We have so much to offer, but the thing is that we have not been able to brand them very effectively. And so is true for the GIs. So I think this is a first necessary step. Uh, so I personally think that if GIs they are effectively managed and they are effectively used, they can offer the kind of advantage to the exporters and growers to have premium prices in the international market. Fourthly, I'm coming towards the conclusion of my intervention. Fourthly, I think that the next logical step is accession to more international WIPO administered treaties, especially the Geneva Act of the Lisbon Agreement. It's a wonderful instrument which enables uh, countries to register their products cross regionally at the international level. For example, European Union itself is a member of Geneva Act of the Lisbon Agreement. So I think this would be the next logical step. I'll just take the liberty, with the permission of the moderator, Dr. Wesab, to just leave one question towards the end of this webinar, is that we have witnessed that Pakistani geographical indications, some of them which are already notified and some which are not, they have been marketed by some international companies. I'm not going to name them right now, but they have been I will say misappropriated. Uh, Although there's a doctrine of prior fair use in the international legal framework surrounding intellectual property, and I think that also applies to geographical indications. But I think that geographical indications are a very specific kind of a category for trademark, which are collectively owned by the citizens of a specific geographic region. So I am not really sure about uh, the applicability of the doctrine of fair use or the prior use for geographical indications. I'll be very honest. I think it would be fair to say that the geographical indication that has been registered very recently, the pink rock salt, I think this has been misappropriated. I have seen companies marketing the Himalayan salt or with pink rock salt on their, on their boxes. So I'll leave this question for our distinguished speakers to answer if this can go on any longer in the future. And once again, thank you very much, Dr. Vaisa, up to you, to your institution and other speakers for this wonderful initiative. Thank you.
Thank you, Saman. I'm grateful. And I can tell you that with a fair comment right now would be that you are in the right place to get that answer, whether that's fair or not. I think Dr. Andrea and Sanaz and Ismail will be addressing many of the points that you have also mentioned. I just forgot to mention some housekeeping rules. There are not many. Um, so I'll request all the participants to keep their mics off. And I'll also request them to post their questions in the chat, and we will take the questions as they will come in. Um, I'm open to having the questions in the middle, but it will be much better logistically to wait for the answers till the end of the session. So let's dive into the session itself. Um, Let me share my screen with you. I think my screen is visible. Is my screen visible?
Absolutely, sir.
Yes, yes, it's visible.
Yeah.
Yes.
Perfect. One big error that I committed, and I didn't want to change it. I did that mistake of writing the time wrong for the CET. So, and I think a few people were already on waiting for the webinar, but the email that I sent later on had the correct time. I also wanted to apologize to those who actually joined the webinar at actually 4 p.m. Central or European time. So apologies for that as well. Okay, so I'll just take a couple of minutes and set the stage for for the other speakers. I'll just give an overview of what GIs are in a very, let's say, macro way. So geographical indications are, let's say, broadly from the family of, identifiers. So we have identifiers such as trademarks. We have, similarly, we have identifiers which are geographical indications. And also, as Salman hinted in his brief talk, um, these are collectively owned identifiers that are used to identify specific geographical origins of products, and at the same time, these identifiers also identify the products to be having certain qualities or reputation due to that origin. Um, so the core thing about geographical indications is the link with the geographical region, and because of that link, there's also some kind of reputation or quality um, in that product which is identified by the GI. Again, as Salman hinted, GIs are actually exclusive rights, um, which which are granted to a collection of, let's say, people who have an interest, mostly farmers, an interest in that geographic indication, to prevent third parties, those who do not have that connection or that interest with that geographical area and the product, from using that identifier on their products which are not coming from that geographic area and do not have the quality or reputation as identified by the geographical indication itself. So it's an exclusive right to prevent third parties from using the identifier on on products which are not coming from that specific area and not having that quality or reputation. Literature specifies that there are different benefits of geographical indication protection. There are socioeconomic benefits, especially with regard to development on a on in that local area, plus on a bigger scale on the national level. Um, Obviously, as an identifier, um, being in that category of identifiers, geographical indication prevents consumer confusion and also, by extension, prevents misappropriation. And misappropriation meaning that misappropriating the uh, property of a collective of people, the property being the GI, and using it for their own product. There are different models of geographical indications protection in the country, in the world right now. Like Pakistan and many other countries, there's sui generis GI protection, which actually mainly means that countries have a standalone specific GI law for protecting GIs in that country. We also have another model, which is uh, collective or certification marks model, which is more in the area of trademark law. For a long time, Pakistan protected its geographic indications through um, collective marks. And since 2020, Pakistan has the GI law, and Mohammad Ismail will be talking about the development in the last 2 years with regard to Pakistani GI registrations and protection. Lastly, there are administrative approval procedures where the government or the government bodies approve um, certain GIs um, and give them the status of the GI protection. Usually, as you can so far understand, and you may already know, GI protection is available to agricultural products, horticultural products, foodstuff, handicrafts, and in certain cases, some industrial products as well. These are some of the examples. You have the Rhine, and I hope, Sanaz, that I'm pronouncing it right, the Rhine saffron, and we have Ethiopian coffee, but we have very famous and king of cheese, actually, Parmigiano from Dr. Zappalaglio's country, that's Italy, and we have basmati rice. And there are hundreds and hundreds of other GIs that exist in this world, and for a long, long time. So this was my brief introduction and setting the stage for my fellow um, panelists. And now what I'll do, I'll invite Sanaz Javadi Farahzadi to actually take the floor, and we will first talk about the international treaties, and then that will be followed by Dr. Zappalaglio's talk about EU regulations, and then last but not least, Mohammed Ismail will be talking about the Pakistan law. Sanaz, the floor is yours. Thank you. We can't hear you, Sanaz. You're mute.
Sorry. Happening all the time, huh? So thank you so much once again. I think this is our second official training together virtually. And my great pleasure to be here with the colleagues in the mission in Geneva and also the colleagues in Pakistan with Andrea. Good colleague and friend, and my great pleasure to be here. It's super hot here. I'm just, melting. So really, I had to just turn off my video a few times so that I can,
It's
So,
44. It's in Karachi, it's 44 right now.
but I would assume that you might have AC, right? We don't have anything here. So we are basically melting in Europe. So yeah, and so let's go ahead, and I don't know if you can see my screen. Can you see my screen well?
Yes, we can.
Yeah.
Okay, is it okay, everything? So because I cannot see anything now, just my slides. So I will go ahead with my presentation.
It's good.
So thank you so much once again for having me here. Thanks for the participants. And I see the name of some of the colleagues and friends in the list as well. I see Natalie from DG Agri European Commission is also with us. Such a great pleasure. I have nothing to say in front of Andrea and Natalie. They're the real experts in GI world, but as an intellectual property expert and as part of my work and the projects that I have been involved with World Intellectual Property Organization, International Trade Center, as well as European Union Intellectual Property Office, I would like to present some of the lessons learned from my practical experience with these organizations. I know that the timing is super tight. I cannot address everything in 10-15 minutes. I just, limit my presentation to some generalities, and as always, requested just for some issues related to international protection. But GI world is so huge, and there are a lot of beautiful stories, tangible and practical stories to address that we cannot address it in this session, of course. But I hope that this would be a good beginning, a good start to continue the conversation. So always a little bit, address what GI is exactly. And I have somehow got this information from FAO, from FAO trainings on GIs. And as I mentioned, knowing about GIs and what geographical indication is and how it can help boosting the economic potential, business potential of local products to be able to enter to regional and international market is not a very brief or short issue to be addressed in few minutes. And for me, the very first training that I had on GIs on behalf of WIPO and the government of France, it was 1 week, like every day from the morning to the night with the field visits, going to the farms, discussing and interview sessions with the farmers. So the GI is a very beautiful and tangible word under intellectual property system, and of course also under the branding scheme that can help local products, including agriculture products, textile, handicrafts, and etc., to be able to brand their products with better qualities and better specification to be able to enter international markets. Of course, like when we say international market, the birth place of GI has been Europe. It has been in, I mean, we have Andrea here, our Italian fellow from Italy, France, Switzerland has been also the pioneer in international negotiations for establishment of international framework on GIs. So the birthplace of GI, I mean, the legal protection has been Europe and mainly Geneva. And so what is GI? As I mentioned and also addressed by Owais, GI is somehow a branding tool under intellectual property system that can link a product to a specific origin with a specific name, specification of the production, and also the reputation that is associated to the place of origin. And of course, for the production of the products, knowing the know-how and know-how of the local communities and local farmers play a major role for the production of agricultural products and handicrafts. And also, a geographical indication has a lot of interaction with other IP issues such as trademarks, traditional knowledge, design, and etc. So the GI protection landscape around the world, as always address, is like it could be addressed under the laws, local laws focusing on business practices or sui generis legislations, or trademark law, for example, in US, in Canada under the certification law, and other means of protection such as consumer law and etc. So the very first major international agreement in place for raising the importance of protection of GIs for, in the very first place, for wines and spirits and for alcoholic drinks was WTO. Which addressed geographical indication as a way for producers to be able to indicate the geographical origin of their products and also provide a linkage to the consumers in terms of the quality of their products in international markets. And it's mostly, I mean, after expanding the scope of the protection, because some of the Islamic countries in Doha round asked for expansion of the scope of the protection of the products to be protected under GI scheme. So now you can have the protection of almost each and every product under the local laws of the countries, agricultural products, textile, handicrafts, and etc. And there are a lot of debates going on in WTO, TRIPS Council, and also in WIPO. So we have two parts of, basically three parts of protection. One is, of course, a national route of protection according to the local laws, if they are accepting the geographical indication system, or as I mentioned, like US, they are more into the trademark system and certification marks. So this is really depending on the local laws, which protection means to use to be able to, certify the products. And also in international phase, we have European Union Intellectual Property Office, and in broader scale in international scheme, we have also World Intellectual Property Organization, which is majorly in charge of Lisbon system, the international framework for protection and registration of geographical indications. So there are some international instruments in place for protection of geographical indications. The very major ones, which was one of the very first conventions in intellectual property system and under industrial property, has been Paris Convention, and then Madrid Agreement for Repression of False and Deceptive Indications, together with the Madrid Agreement and Protocol, which we call it Madrid System for the Protection of Certification Marks, as well as Lisbon Agreement that I will address briefly, together with bilateral or even multilateral agreements. For example, in international negotiations, in diplomatic relations, we also have these bilateral negotiations between the countries, between Switzerland and contract parties, or between EU and some other business counterparts, to have intellectual property provisions, and under that GI provisions to provide protection to the local products of the targeted country. So again, I mentioned that this is again, it goes under the local laws of each country to identify the scope of the protection of the local products under GI system. Andrea will address this, I think, that in the very first place, what we had, for example, in EU level, now what we are covering under EU system. So this system is really expanding, and also more and more countries are joining Lisbon Agreement. In the very first place, we had only few countries joining Lisbon. But now we have around 38 contract parties covering 57 countries, including EU, joining Lisbon system, which this system provides you the international protection in all these countries by a single registration procedure, and with the payment of one set of fees through, electronically through World Intellectual Property Organization system. So as I mentioned, there are two basic and major organizations dealing with GI issues. One is WTO, and covering all GI regulations under TRIPS agreement. So all political negotiations for GI issues goes on in TRIPS Council. And for the protection phase and registration of the GIs, we have World Intellectual Property Organization, or WIPO Lisbon system. So as I mentioned, the major registration system in international phase at the moment is Lisbon, depending if the contract party has local GI laws, or Madrid system for the protection of trademarks or certification marks under the trademark system. And as you can see, under those both of these systems, we can have the protection for all categories of products. So it's not limited to wine and spirit or only to agriculture products. And there is also this debate going on in the branding committee of WIPO, which is including the discussion on trademarks, geographical indications, and design, on how and which products to protect. And there has been some debates also to protection of local services that the communities are providing. For example, Brazil addressed it, that some of the local services are protectable, and this country would like to offer the protection for these sort of services. So this system is really under the promotion and expansion. There is a lot going on at the moment in international level, and a lot to do in near future. So the legal effect of international registration is that the registration is unlimited. So opposite to other IP rights that are limited in time, for example, trademarks, mostly up to 10 years protection, or patents to 20 years protection, as long as the local producers are producing a single type of the product according to the specification specified under the GI system, this product can be permanently and indefinitely protectable under the laws, in principle, of course. And once you have the protection in local phase, you can have the expansion of your protection to other countries rather than the country of origin, as I mentioned, by Lisbon system. Except in a country, you cannot seek the protection in a country that issued a refusal, which is like applicable to other intellectual property rights as well, or if your application has been invalidated in the effect of the international registration in its territory. As I mentioned, GIs are mainly protected in WIPO through international registration system, which is mainly Lisbon system for GIs and Madrid system for trademarks. WIPO is also providing technical assistance in the form of training and policy work, and assistance to the local governments and local producers, to the member states for expansion and promotion of the GI system, and also the protection of traditional knowledge, because GI is mostly protecting the products that the way of production is related to the traditional knowledge and is a knowledge of local communities and rural communities that they have possessed this knowledge for ages and ages, and this knowledge has been passed from generation to another generation. So there is also an interaction between the protection of traditional knowledge and GIs. And just a few weeks ago, we could have, after 2 decades of negotiation, we could also have the International Convention for the Protection of Traditional Knowledge, Genetic Resources, and Folklore in WIPO. So we will see in future how the local regulations of the countries will evolve in terms of protection of the local products. And of course, WIPO is in charge of, holding conferences and also debates in the Standing Committee on the Trademarks, Designs, and GIs. And of course, there are a lot of issues, not on GIs that much or yet, as far as I know, but under the total branding scheme under the arbitration center of WIPO for dispute settlement in terms of domain names. So domain name system also provides you with some possibility of having, as Owais mentioned, if there is any sort of misappropriation, there is also this possibility of reflecting the issue to the dispute settlement body of WIPO, which is arbitration system. So these are also, again, the general, always please interrupt me if I'm passing the time, because I can go on and go on. And so, as I mentioned,
you have 5 more minutes. So.
5, okay, perfect.
Yeah.
So geographical indication is really the core of quality control. I would like to address this fact that unfortunately in many developing countries, I'm coming from Iran, including Iran, many producers or even the local governments, they have this impression that once you register the GI, the protection has been met and there is no need to do any additional step, which is wrong. GI is different from trademark system. For having an appropriate GI system, you should have a very consolidated, how do you call it, system in place so that you can have, I want to show you the slide on I think I removed it maybe, no, here. So you should meet 5 pillars to have a sustainable GI system. In the very first place, you should have a GI organization. This GI organization could be a trade union or a trade association, which is in charge of identifying the rules and specification for the production of certain product. For example, for the basmati rice. In order to have a practical and efficient GI system in place, mere registration of basmati rice under GI system is not sufficient. There should be an association as the owner in charge of protection of this product and promotion of this product to identify the book of a specification. What is the book of a specification? We mentioned that the core element of GI product is quality. In the book of a specification, the producers, they sit together, they discuss, they agree on the specification of the products that they are producing according to the traditional knowledge that they hold. I mentioned that this knowledge can be passed from generation to another generation. And how to produce, under which scheme, under which specification, how would be the package after the production, how would be, if this is for example, in agriculture sector, if this is a bio product, organic product, or this is a normal product, how would be using the pesticides and all, agriculture methods that the producers are using, or how should be the quality of the product, for example, for the basmati, the taste, the color, the size, and how it should be protected legally, how it should be priced, how it should be packaged, to which country it should be produced. And all this is some sort of Bible or some sort of lead for the local producers to follow. And of course, you can always customize the book of a specification, but only the local producers who are bound by the book of a specification can use the registered GI. and they have to obey the regulations already inserted in the book of a specification. And also there should be, because another specification of the GI product is the link, the origin, the delimitation of the certain product to the production area, to a certain region. And also the most important part is control and traceability system to provide controlling system for meeting certain quality in the product. And when you wanna, I think it would be the same in Pakistan as well. When you wanna apply for the protection of your GI product in national phase or international phase, you should provide the proven link. You should provide even the how, I mean, the evidence on how this product is produced in certain region and what this region is exactly. What are the geographical boundaries of this product? So each GI system should meet these 5 pillars. Otherwise, this is not a proper and efficient GI system. So in many countries, we have GI laws in place. We have GI registration system in place, but there is no GI organization in place. There is no book of a specification and no control system in place. So these are the issues that when governments want to implement the GI system should take into consideration. So I have to go back. So
Sanaz, you have another maybe a minute or so. So I don't know if you would like to, highlight
I
the
will
important
wrap up.
points.
Yeah. So I will wrap up to indicate that geographical indication is so important for the economy of the countries that in certain countries, I was in charge of the projects in Southeast Asia and remotely now in Africa. So sometimes for the case of, you can Google and you can read about the Kampot pepper of Cambodia, which is a very famous GI case. The protection of the product under GI system is so important for the economy, for the boosting the local economy, national economy, or even the tourism in the specific region, that the countries, the governments have identified a special flag for their own products to use this tag or flag or logo behind their product for the sake of export. So there are a lot to say about the advantages of GI and also the deficiencies that most developing and least developed countries are suffering from having the GI system. But I just really like going out of the international scheme. I would like to address this part as my last point, is that the component for a successful GI system is, okay, we should have legislative background, we should have proper legislation in place, we should have a strong organizational and institutional structure in place, as I mentioned, for example, the GI organization, and there should be effective public-private partnership between the local government as a supporting authority together with the private sector as a main beneficiary of a GI system. We should have GI organization in place. We should have a appropriate control mechanism and marketing strategies, and also after the legal protection and commercial protection, I mean marketing scheme has been identified, the last stage would be providing advertisement and awareness raising campaigns for the consumers, especially in export markets, so that the international consumers can know about the products that you are protecting, so that you can enhance the market share or market potential of your GI products. So I will finish at this point. Again, I emphasize there is a lot to say. I couldn't be briefer than this, but I hope this can give you some idea what is happening, in international level. And I will also share my slides so that you can use it at a later stage. But I just, as an ending point, I would like to mention to the very recent study I did for European Union Arise Plus IPR team in Southeast Asia. on the role and involvement of women in local communities with the emphasis on GI system. This is a very, because always mentioned that I'm a women rights activist. I'm not a women rights activist, but I'm working on women and intellectual property issues and how to empower women from economic perspective through effective use of intellectual property system. So within this study of European Union Intellectual Property Office, we identified and we analyzed the effect of protection of intellectual property rights, including GIs for women in Southeast Asia. Because in Southeast Asia and in so many other regions, women are the major holder of traditional knowledge and they are the major producers, especially in family businesses. So the protection of GIs can help them to be able to enter the international market. So this study is one of the very first ones that has happened by now in terms of addressing the branding aspects of intellectual property system and the relation with women, how to empower women through branding. And I know that WIPO is also doing some initiative on this as well, but I just wanted to mention that there are a lot of parallel activities going on in international level now to address the importance of GI protection for local communities and for the economy of the member states. Thank you so much. I will finish at this point, and if you have any questions, you can drop me an email here. Thank you so much.
Thank you, Sanaz. Thank you. I knew already that holding your passion back will be very difficult for you, and I totally understand this. It's okay. And I thank you for the very clear exposition of the international rules. Plus, I really like the 5 pillars that you mentioned, and I think it's very important for countries to have a structured, actually, way to implement the GI laws, because these are many countries do not have much experience in the area. I'll take the opportunity to give the floor to Dr. Zappalaglio. I'm really grateful that you're with us today, and I don't know how hot it is in the UK, if you're in the UK at this point, but yeah, please go ahead.
Thank you, Professor. Well, first of all, here it's 28 degrees, which is an exceptional temperature for UK standards, but you know, in Milan it's like 36 now, so it's you know. And I will share my screen. So please let me know if you can see my screen and my slides.
Yes, it's visible now.
Fantastic. Let's see if it works. Yes, they do. And yes, in my presentation, I will very quickly present the EU sui generis GI system, which is of course quite a challenge in a short time, because you know it's like saying talk to me about trademarks. You know, now probably it's even more complex because we have like 5 GI regulations in the EU. Instead, trademarks are 1 or 2. But I'm very happy, and I really thank you all for the invitation, because I think that Pakistan is a country with a huge potential in the field of GIs, and so you know it's great to have this conversation all together. And basically, as Sanaz said, the EU considers itself as the leader in sui generis geographical indications protection. So with sui generis, we mean when we protect geographical names with a specific ad hoc system. So we do not protect geographical names using trademarks like let's say the Anglo-Saxon / North American common law approach usually does, but we have a specific system. And it is no secret, of course, that the EU, the European Commission, has been betting and you know stressing the importance of this system for a very long time now. And of course, the first examples of appellations of origin and sui generis GI protection in Europe dates back to the 30s, basically, 1930s France. At the end of my presentation, I will show a little bit of bibliography if you're interested in knowing sui generis GIs in the European region, so not just in an individual member state. I think the story starts in the 70s, where we had the first regulations on wines. Now, bear in mind, these were not exactly regulations on what we call the quality schemes. So they were not regulations about designations of origin, the geographical indications, etc., etc. But the idea was, start building European communitarian market with common standards. And you can see here basically some examples. For instance, you can see Regulation 2133 of 1974 about general rules for the description and presentation of wines and grape musts. So this means we must have common standards, common rule, which we all follow when we market wine in the European marketplace. And why wine? Well, it's well known that wine is the most, let's say, valuable, precious GI product, and both within the EU market, but also when we look at the export figures, something which I will show you in a second. So, wine was a priority. And then in the 80s, we had something pretty similar about spirits. So again, this was not really a geographical indication, but it was mostly about introducing common standards about, how we label and how we name spirits. So looks like something surprising, but if you create a community of states, you must agree on what vodka means. What is vodka? When can you sell something under the name vodka or whiskey or whatever? So the real turning point was 1992, where we had the first regulation on the protection of geographical indications for agricultural products and foodstuffs. Oh, sorry, I see that here there is a little mistake. It's not 2082, it was 2081. I think I made it right in another slide, but I will correct this later. So this was
just a quick interjection. Is it just me, or we are still on the first slide? I
yes,
don't know.
we are on the first. We are on the first slide, but I only have 6. So
no, it's totally fine. I thought that you were moving forward, so it's totally fine.
No.
Oh, good, perfect.
So basically, this was the regulation when the European Union decided to protect agricultural products and foodstuffs, introducing specific labels, so the designation of origin and the geographical indication. And then in 2008, this was extended to wines and spirits. And in 2014, we had a new regulation on aromatized wines, which is a bit of, let's say, minor scheme. And I will explain you why in a second. Then we had quite an intense reform process with some amendments to all the major regulations, and now this novelty, which is a regulation proposal on quality schemes for crafts and industrial products, which will come into force on 1 January 2024. And on a personal note, I think this is a very important and necessary innovation. And as a scholar, I've been advocating for this for years. If you take a look on YouTube, you can still find videos where I argue against people who were skeptical. So I think this is very important. And this is also very important to enhance the relationships between the European Union and other countries with a very rich heritage of handcrafts and similar products. And Pakistan can be one, India is definitely one, etc., etc. So basically, this is what we have today. So we have a regulation on agricultural products and foodstuffs, which is the 1151/2012, as you can see, recently amended in 2021. Then we have for wines the regulation 1308/2013, again recently amended. Spirits, we have this new regulation, the 2019/707, and then aromatized wines. Now, this is when it comes to aromatized wines,
But I'm
something.
sorry, I need to jump in again. I'm still on the title slide. We are still on the title slide. We are not
Really?
on the second. Yeah, so that's what I wanted to point out. So we are
This
still on
is
the title slide.
this is absolutely weird. Can you see now?
Yes, now.
So let's see if I
Uh,
can go full
Would
screen.
you? Yes, exactly.
Now, do you see the slides turning?
I do see this the second slide, which is the first slide
Okay.
after the title,
And if
but
I
it's
click
not
on the
full screen.
this is
It
very
will
weird.
go. It will come. I think it will come.
Let's just try a different thing. Just a second. Let's try to, if I share the full screen, maybe it works better. Can you see now the slides
Perfect.
moving?
Yes. Yes.
Fantastic. So
Perfectly fine.
sorry,
Thank you.
sorry
Thank
for the inconvenience.
No problem.
And so basically, this is what we currently have now. With well, but anyway, the important thing is that we have recently ended a round of reform proposal for crafts and industrial products. Aromatized wines have basically now been associated to agri-food. So basically, the register is the same, and aromatized wines have become an appendix to the agri-food regulation, even if they also have their own regulation with other rules. But from the point of view of registration, basically, the two systems have been merged, especially because at the moment we only have 2 aromatized wines on the register. So, keeping them as a standalone category was probably unnecessary. And the European Commission has repeated several times that, we need to simplify. So, yeah, this is, of course, something that goes towards a simplification process. So, but since we like to make our lives a bit complicated, we have, let's say, 3 different systems: the protected designation of origin, the protected geographical indication, and the geographical indication, which actually works in a very similar way or almost identical way as the protected geographical indication. But the terminology is different. So basically, we have 2 main kinds of label indications. So here things get a little bit complicated because the protected designation of origin applies to spirits and aromatized wines and crafts. Now, this is basically how the European Union, ratified, transposed into its law the appellation of origin model, which, it's a model which originated in France, and then it was translated into international law with the Lisbon Agreement. Now here, the producers must provide evidence of a link between the product and both the natural and human specificities of the area. Sometimes this is indicated with the French term terroir. So you have to show that your product has a very strong link with both the environment, the local environment, and of course, human specificities, which can be, of course, specific methods of production, etc., etc. And the product must be entirely produced in the designated area, and raw materials must be sourced locally. So there are some exceptions, of course, but this is the general rule. So for instance, if I make wine, I must use just local kind of grapes. I cannot import them from another region, from another area. If I am making any other products, I don't know, if I'm making bread, I must use locally sourced raw materials. The protected geographical indication instead is basically the TRIPS agreement paradigm, the TRIPS agreement model. In this case, it is applied to agri-food, wine products, and aromatized wines. And as you can see, the link is less demanding. So you can, of course, provide evidence of a qualitative link, which basically means that the characteristics of the place influence the quality, so the features of the product. But also a reputational link is enough. So you can say there is a link because consumers believe that associate that geographical name with a specific product, or you can say it is known that that product comes from that place. Why? Well, because this is what consumer think, or because this is what the history of the product tell us, etc., etc. Now, in this case, just one step of the production process must be carried out in the designated area if we are talking about agri-food products. Now, this is a very loose requirement because the production process is everything that goes from the sourcing of the raw materials until the end product, with the only exception of optional operations like cutting, slicing, grating, of course, packaging techniques, whatever. So if just one step of the production process, from the sourcing of the raw materials until the end product, takes place in the designated area, you can have a PGI. In the case of wine, this translates into this, that we have at least the 85% of grapes must be local, but you can always import up to the 15% of the grapes from another area, which is, of course, something you cannot do with PDO. Again, there is no obligation to source raw materials locally. So in this case, if I make bread, I can source, I don't know, flour or other raw materials from another area. That's not a problem. Then we have the geographical indication, which, as you can see, the label is the same as to the protected geographical indication, but the regulation calls it geographical indication because it applies to spirits and crafts, and it is the only label that can apply to spirits and crafts. So in the spirits regulation and the crafts regulation, making a distinction between PDO and PGI made little sense because you have just one option. So basically everything I said concerning protected geographical indication applies here. So for instance, if you produce a spirit, at least one stage of the distillation must take place in the designated area, but it's not necessary for the whole process to take place there. Again, we have exceptions, but this is the general rule. And again, no obligation to source raw materials. Including the industrial products and crafts, which is not into force yet. 3 labels, and this is more or less how they work. Oh, by the way, everything here has its own register. So agri-food products have their own register, wines have their own register, spirits have their own register, and crafts are going to have their own register. Another thing which maybe is useful to add is that, curiously enough, The use of these labels, which you see here, the red one, the blue one, is mandatory only in the field of agri-food products. So if you produce an agri-food product, you must use them. In every other cases, the use of the label is optional. So if you produce a PGI wine, you can write it down. You can say, I produce wine X PGI, but the actual use of the label is not mandatory. Same goes with spirits. Just to give you some numbers, as you can see here, we have a little less than 1,600 agri-food products and a little more than 1,600 wine products. Spirits are less, and aromatized wines, well, pretty rare. So as you can see here, probably unsurprisingly, you see that now the PGI is by far the most popular quality scheme in agri-food products. Why? Because it gives a lot of flexibility. It provides a lot of flexibility, but also because there are some products which can't really be PDOs. A typical example may be bakery products like bread, etc., etc. It's often hard to prove the existence of an essential link between the product and the place. In fact, bread PDOs are very rare in the EU, and it often happens that if you make bread, you import raw materials from another area. Instead, wines are dominated by PDOs because in this case, the link between the product and the place is very intuitive. Grapevines grow from the soil, so it's way easier to make an argument. Again, spirits, aromatized wines only apply the PGI-GI system. If you want to know a little bit about the value of UGIs, you can find this. This was published in 2020, if I remember correctly. It's a study commissioned by the European Commission. And so if you're curious to see, the value, it's all here. Probably it's pretty interesting to observe here that despite the efforts, GI products are still very national. These are the sales, so you can see they are mainly sold on the national market. Intra-EU market is still sometimes a bit rare, and extra-EU market even rarer overall. Just see the difference between the sales of agricultural products and foodstuffs on the national market and the exports value. That's pretty telling. So again, you can see that wines and spirits are doing well. So there are important exports. Agricultural products are still mainly national in nature. By the way, it's not here, but it's been calculated. This is something that may be of interest also for Pakistan or any country who is exploring the possibility to invest in these quality schemes. That in the EU, GI give a 2.24 price premium to producers. Translated, this means it has been calculated that a GI product can be sold at a price which is more than twice as expensive as the price of a similar product without the GI label on it. So the effect of GIs on the marketplace, it exists and it's real. Then, of course, we must pay attention not to generalize. There are, few products which dominate the GI market and many products which are less known. But this is what economic analysis is telling us. Just a very last slide here. There's also another scheme which is called the Traditional Specialty Guaranteed. As you can, this is the rule. can protect agricultural products and foodstuffs, the name of which result from a mode of production, processing, or composition corresponding to traditional practice, or that are produced from raw materials or ingredients that are those traditionally used. And to be protected, the name needs to have been traditionally used to refer to a specific product or identify the traditional character of a product. Now, this is a residual scheme, although I find it very interesting, but we have only 67 registrations to date. This is because of a number of reasons, which I can't discuss here, but basically, it's not an origin label. If you read the rules, you see that the applicants do not have to prove the existence of a link between the product and the place. In this case, protection is given to products which can be presented as traditional in nature. It is usually a system which we use to protect generic names which otherwise would not be protected. Maybe the most important and famous example is the pizza napoletana, the Neapolitan pizza. You know, it was invented in Naples, but now, you know, it has become a global product, so you cannot prove a link between the product and the place anymore, and yet you can show that it is traditional in nature, and you can codify and protect the traditional recipe. Now, in the EU, usually this quality scheme is not that popular, but I know that a lot of, well, a lot, not a lot maybe, but many non-EU countries find it interesting for a very simple reason, that the concept of origin link, which is the foundation of the EU GI system, is sometimes not very well understood outside the EU, and this is due to cultural reasons. Is a very French/Italian based concept. But the concept of tradition and traditional product and heritage product is instead way easier to understand internationally. And so this is why sometimes I speak to officers of I spoke, for instance, with officers of the Argentinian government, of the Indian government, and they were all interested in knowing something more about this, because they hear the word tradition and they say, well, this is something we can understand. This is something we can use. If you want more, these are some of my recent things, and Professor Owais was mentioning this book here. But before coming to Sheffield, I was also the coordinator of the GI research team at Max Planck Institute in Munich. And this is the result of our work. This is a very heavy empirical analysis, which we published in February. So if you really want a very boring piece of research full of data, empirical trends, etc., if you want to know something more about traditional specialties guaranteed, I have a forthcoming article about it. But also, I would like to tell you that this book about DevGang G on geographical indications, it was published 10 years ago, but I believe that it's still one of the best books you can find, especially if you're interested in the international and if you want a conceptual map of GIs, especially at international level. So I hope I didn't exceed my time, and thank you very much for your kind attention.
Thank you, Dr. Zappalaglio. It was really, for me too, it was really an enlightening talk. And whenever I'm hearing about, listening to somebody who's actually talking about EU GI protection system, at some point I cannot help think why the Europeans have made it so complicated. Layers upon layers. But then I also start thinking that it's also the experience of the last 50, 60, 70 years that they have actually, rightly or otherwise, I don't know, incorporated in the different schemes. Yeah, but it's really interesting. And I also see that you were at the Max Planck, and I think we missed each other maybe by, I don't know, 2-3 years. I was there till 2016 before coming back to Pakistan. And Dave's book is actually, it's the Bible. in the GI area. It's at times it seems like he's actually preaching. You read the book, you realize, oh, he's preaching. It's not just that he's preaching everything about GI is good, but he's so convincing. And I was lucky to have been taught by Dev at the Max Planck about GIs when I think he was at the LSE back in 2009. Yeah. So yeah, it was great listening to you, Dr. Zappalaglio. We'll move now to Mohammed Ismail, who is representing Intellectual Property Organization of Pakistan. And we're I think a lot of the attendees are also very keen to hear about what is the Pakistani law. I'll not keep you from presenting. So Ismail, the floor is yours. Thank you.
Thank you very much, Owais, and thank you very much, everybody, for joining this session. I would like to share my screen first. Owais, is my screen visible?
Not yet.
And now? Is it visible?
Yes.
Yes.
Yes, you can see here webinar by SABUL on regulating geographical indications, and this is my presentation, Geographical Indications, Registration and Protection System in Pakistan. So I will briefly introduce about GI system in Pakistan, what legal system we have, what are the salient features of our GI law. As you have also mentioned, and Mr. Salman, that our GI law is a very nascent GI law. We have enacted GI law in 2020. Previously, we had collective marks and certification marks for these types of products. Then notified GIs of Pakistan. Then we will talk about role of my organization, IPO Pakistan, under the GI Act. Then what is the GI registration process here in Pakistan, and what are the benefits of our system for the owners of the GIs. As far as our GI legal system is concerned, Geographical Indications, Registration and Protection Act was enacted on 31st March 2020, and we notified rules thereunder in December 2020. We have notified 65 GIs under this law, and currently we are working for registration of these GIs. The notified GIs list is available on our website. I will not go into the details. You can just visit our website and you can see the whole list of our notified GIs, which are under process of registration. And current status is that out of these 65 notified GIs, 3 GIs are registered nationally in Pakistan, and those are Basmati rice, pink rock salt of Pakistan, and Hyderabad bangles. So our GI law speaks about the geographical indication. We have given the definition of GIs under our law. There is no need to go into the details. Then our law also provides mechanism for registration of GIs. We will discuss very briefly about this on next slides. Then our law mentions that GI registry will be working under Intellectual Property Organization of Pakistan, which I am representing here. And then very important thing in our law, the components of our GI system. These are authorized users, registrants, and certification bodies. Then we also provide higher level of protection for registered goods, and remedies for infringements are also available there in our law. Civil remedies as well as criminal remedies are available. And very important thing in our law is that foreign GIs enjoy the same type of protection which they enjoy in the country of their origin. So if a GI is coming from Europe or coming from France or coming from Switzerland or Iran, that GI will have the same type of protection here. What protection they have got in their country of origin. So our GI system, geographical indication, registration, and protection system, has basically 4 components. First of these components is the state, the government of Pakistan, According to our law, the state will be owner of all geographical indications of Pakistan. And the second component is the registrant body. The federal government shall appoint any public body to be registrant of GI. For example, Trade Development Authority of Pakistan is registrant body for basmati rice. The third component of our law are authorized users. These are the producers, operators, processors, traders, exporters, etc. These are the real people who are getting economic benefit from this system. All the system has been devised for these people who are authorized users. Then another component is the certification body. The concerned ministry notifies the certification body, and certification body is basically for the control of the product. So these are four pillars of our GI registration system in Pakistan. As far as registration system is concerned, so there is no fee for registrant body because they are custodians on behalf of the government of Pakistan, and there is a very nominal fee for authorized users for their registration. Then registration process is also very simple and it just takes 3 to 6 months, and protection of GI is unlimited without any renewal for registrant bodies. Authorized users have to renew their registrations after every 10 years. What is the role of my organization, IPO Pakistan? IPO Pakistan is basically responsible to manage and control geographical indication registry in Pakistan. And our GI registry is responsible to receive and examine applications, then receive oppositions and counter statements for authorized users, then register geographical indications and manage register A and B. Register A is about registrant bodies and register B is about authorized users. And then GI registry has jurisdiction all over the country, all over Pakistan. Like other countries, geographical indication is a territorial right in Pakistan as well. So what is the process for registration? There are 7 steps in the registration process. First is notification of registrant body by the federal government. For 65 GIs, federal government has completed their notification, and now we are working for registration of these GIs. Second step is preparation of book of specification by the notified registrant. Then third step is consultations with stakeholders for finalizing the book of specification. And when book of specification is finalized, then application is formally filed at GI registry of IPO Pakistan on form GI01. Then our GI registry examines the application and publish it, and finally the GI is registered in Pakistan. So these are 7 steps for registration of GI in Pakistan under our Geographical Indication Act of 2020. Then what are the benefits of our GI legal system? As you know, and mentioned by Dr. Andrea also, the registered GIs have premium quality and enhanced value. Then economic benefits to the producers and all supply chain. These are also helpful for rural development and business promotion, and mentioned by Ms. Sanaz in her presentation. Then obviously job opportunities and export development, and then tourism development in the local area, as mentioned by Mr. Salman in his introductory statement. So this is all about the GI registration system in Pakistan. This is our logo for registered GIs of Pakistan, which we assign to the authorized users who can use on their products when they are exporting or when they are trading in the local market. This is logo for registered geographical indications of Pakistan. And thank you very much. It's all about my presentation. Owais, over to you.
Wow, thank you, Ismail. That was brief, and but still, you managed to cover all the important points that were there to be covered. I'm thankful to you for that. We'll see if there are different questions that are needed to be that have been posed to the speakers. So please, you feel free to actually write your questions in the chat, and I'll take them in a sequence. So this first question is, what measures are being taken so far regarding encouraging the underdeveloped countries to get their originated products recognized internationally? I think it's a very broad question, and I think any one of you can take if you want to. If you want to. Are different measures that are taken to encourage developing countries?
Who will answer, Wes? Who will answer this question?
It's open. It's open. I mean, it's not asked to a specific presenter, so anyone can take it.
Okay, as far as Pakistan is concerned, the GI law is enforced in Pakistan. As I have mentioned, we have civil remedies as well as criminal remedies against the misuse of registered geographical indication in Pakistan. As far as civil remedies are concerned, the damages and compensations are granted to the owner of GI by the violator, and these damages and compensations are granted by the IP tribunal, specialized IP tribunal in Pakistan. And there are also criminal remedies available against the misuse of the logo and also misuse of the GI in Pakistan. And these remedies are imprisonment up to from 6 months to 1 year, depending on the situation of the violation. So these two types of remedies are available under GI protection system in Pakistan. And as far as international protection is concerned, I think Ms. Sanaz or Dr. Andrea will be in a better position. What is mentioned under the Lisbon system or any other Paris Convention or system like this for industrial property and other types, geographical indication and other types of industrial property. So over to you, please, Sanaz and Dr. Andrea.
Well, I mean, Sanaz, do you want to say something, or can I go with my
Please
version?
go ahead. Please go ahead. But I might add a few points. Thank you.
Oh, well, I think it's a pretty difficult question for the simple reason that every country is different. So the point is that geographical indications don't work in a vacuum. And what I usually say when I am asked these questions is that GIs actually work if you have already a kind of agricultural system in place, and then GIs can be the very last thing to promote and enhance what you already have. So I know that there are several projects ongoing. I know WIPO is providing a lot of technical support, but also the EU, but also in European countries. I know, for instance, France is very active. Also Switzerland, which is not a EU member, but is also very, very active. So it's very hard to provide a comprehensive answer because we have various case studies. And when you identify a community which is interested, you have to support it, teach them what to do, how to do it. And I think the most important thing is to help them to draft a specification that can represent faithfully what the product is and what the tradition is. And after that, I think you need governmental support. In my experience, GIs supported by the government work better than other approaches. And once you have it, if your country is a Lisbon Agreement member, you are in a better position. Otherwise, it's just a matter of promoting this and finding the right experts that can help you in the process. But it really depends on the situation. Asia is not Africa, which is not South America. So, it's complex.
Yeah, I would like to also add, in completing what Andrea said, there are a lot of initiatives at the moment on behalf of different international organizations, major one, WIPO, of course, EU, European Commission, and also Swiss IP Institute. But I mean, Andrea, you mentioned to the fact that there should be a proper agriculture system in place. I would say that in general, because I've been working, I think, I don't know, in so many countries and developing, least developed, even in Switzerland as a pioneer in IP system, still the awareness on intellectual property system as a whole as the basic for economic development, especially the role that intellectual property assets can have in export or in digital economy, is really low. And when it comes to GI, people ask, what is GI? And in my last slide, before presenting EU IPO project and women and IP, I mentioned that this coordination between governments and private sector and coordination among local producers themselves is really a key. And this cannot be met easily. The governments, private sector together, if they can work very well, and among the local producers themselves, there are very few cases because we've been witnessing different producers in different regions, from coffee, from different spices, from textile. The local producers are also not cooperating with each other. Why? Because there are sometimes some producers who have the major market share in hand. They have their own market position, so they block the whole GI promotion. So there are a lot of issues that are somehow slowing the progress of GI system. And of course, we should always remember that the huge markets like US, they are not pro GI. Of course, we can always use certification marks, but this is another hindrance. If you go to WIPO website, you see how many member states joined to PCT, how many joined to Madrid system, and a little bit like few countries joined Lisbon after a lot of discussions, negotiations, full support of WIPO branding sector, all these years and years of discussion in WTO TRIPS Council in WIPO. There is still a long way to go. And I think always maybe, I don't know how many GI sessions you have had in Pakistan before, even in Iran, even in Switzerland, I don't hear much, In Iran, if WIPO or Swiss IP Institute doesn't do anything, no one knows about GI. So this is why we just started, on a continuous basis, because the issue is what? People come to this meeting, they are happy, they come to the conferences in person, they interact with each other, they leave the room and they forget. So this conversation should continue. It's not just a matter of, having an awareness raising session. Okay, GI is important, everyone. So what's next? So this should be on continuous basis. And as Andrea mentioned, each and every country has their own priorities. They have their own economic structure, social issues, cultural issues. So there are so many issues related to GI. And as I mentioned, GI is not like trademark or even patents. There are so many issues surrounding. Yeah.
You are muted, always.
It's very interesting, the take of all the speakers on that question. It's so broad that it allows us to actually speak our minds out. I remember back in 2006 when I was at the IPO. The question can be tackled from another level. At the IPO, the question at that point was, how can we protect these geographical names, these identifiers? At that time, it depended upon which country or which region was actually influencing our IP understanding. And at that time, the Trademark Act, the trademark law, the new trademark law came into was promulgated, and we had the certification mark scheme. We had the collector mark scheme, and then I don't know because of why, I suspect because of expediency, we decided to stick to the easier route, which was existing already, the certification marks route, the collective marks route, and I'm stitching this to the question that was asked: what measures are being taken? So from this level, from a different perspective, we can I can also say from my experience that countries who are not IP native, in that sense that the IP laws, they were not creators of IP laws, they are highly dependent on who is influencing or who is actually reaching out to them in which area of IP, and what are they telling them. And that's one of the points that I think Andre also highlighted, and Sanaz just right now highlighted. There's a need that there's always a need of a homegrown IP specialists, let's say, who actually do understand the different aspects of all the, let's say, IP policy, IP laws, and what is being asked them from different trading partners. So this question was so general that it prompted from all of us different responses. So thank you, Mansoor, for asking this. We had another question by from Mansoor, which actually was already answered by Ismail. So I'll go to the next one. There are certain comments. I'll come back to them if we'll have time. Natali Nathan is actually asking, do the IP Office of Pakistan has a publicly accessible GI registry? So I think that's a question to Ismail. Do we have a
Whereas
publicly
I have given answer in the chat box. Please see that answer, and if you have control, please forward it to all participants. I have given answer to both questions by Mr. Nathan. Please look in the chat box.
Okay. We have complete registry and publicly available information on our website.
I have given answer
so there's the link.
The questions by Mr. Nathan and also question by Mr. Muzammil. So if you have any other question, please forward me so that I may give answer in the chat box, or if
you can feel free to verbally provide your reply. It's totally fine. So there's a link that you have provided in response to Natali's question. Sorry, it's in the chat box. So yes, there's a complete registry and publicly available information on the IPO Pakistan website, and the link is there. You also replied to the second question, which was, can the Pakistani GI logo also be used by foreign GIs? And the answer to that is yes. The
Dear
GI
Nathan,
logo
GI logo
can
of Pakistan can be used only by Pakistani GI owners, because the foreign GIs, when they come here in Pakistan, they can use their own logo. So our logo can be used only by the local GI owners.
So my follow-up question would be to that would be, what would be the indicator of a registered foreign GI registered in Pakistan?
We will issue registration certificate, and they can use their own logo which they have used in their country of origin.
Oh, the same basically, logo that they...
Yes, basically GI logo is from the country of origin. For example, a GI is coming from Iran, and Iran GI office has assigned a GI logo to the producer. They will use that GI logo all over the world where they go for registration. The only thing is that they are authorized to use their GI logo in Pakistan according to our registration. When they come in Pakistan, we authorize them to use their own logo. You have seen so many EU logos on the slides by Dr. Andrea. So these EU logos can be used by the EU GI owners themselves when they come in Pakistan, especially. And we authorize them to use your logo. It is just like a trademark. You can use your trademark whenever you go in another country.
So without authorization from the IP office, they can't use their GI origin logo?
According to, there may be some procedure, then the other systems also apply. They can use, but then they will have to provide prima facie evidence for that use. You know, IP registration is a voluntary registration. It is not compulsory. When you go in the court of law, then you have to prove that. Yeah.
Perfect. We have the next question
property is your intellectual property, whether you register it or not. But when you come for registration, it is double protection, or it is a certification by the government that you are the owner of that property. If you don't register your IP right, you still are the owner of that IP right. But you will have to prove in the court of law with so many evidences.
That's true. That's true. Thank you, Ismail, for that answer. The next question is from Salman Khalisab, and the question is from his talk in the beginning. Is the doctrine of prior use applicable after a GI is protected? So when you say prior use, you mean prior use in a trademark sense or in a GI sense or in any way?
Well, I think that's the question is also that about that because GI is kind of more of a latest phenomena in the overall debate of intellectual property, at least for countries like Pakistan. So what I wanted to understand was that what we have witnessed is that many Pakistani GIs, which are famous worldwide already, even before registration in Pakistan, we have seen that they have been marketed. Of course, they have not been claimed as as a product from another country. What I have personally seen is that, especially in case of pink rock salt, a number of products around the world, they mention that it contains that. What my understanding is that as long as the GI is protected, this should not be allowed. But then also comes into mind the question of the territorial jurisdiction that was also related to what Ismail Saab was talking about earlier. That for instance, if pink rock salt is not registered, it is registered in Pakistan, but it is not registered in another country, and there you find such kind of marketing, uh, then what could be the way forward? Yeah. So thank you.
Okay, so maybe Sanaz can go first and tell us about what TRIPS says about this, and then Dr. Zappalaglio.
I wasn't listening to this last part. Can you repeat it, Owais?
Yes, I'll repeat the question. Is there a doctrine of prior use applicable after the GI is protected? If the same GI has been used prior to the registration of a GI in a country?
I mean, I think, Andrea, please correct me if I'm wrong. This is mixing the GI system with trademark, because I think each and every product, they have their own specification, even in the similar products, such as rice, or like, I don't know, handicrafts, or saffron, or like each and every product they have their own specifications. So I'm not sure up to what extent. I mean, of course you can apply, like, I mean, you can say the prior use, but how you can justify it? Because prior use in GI system is different from trademark. In trademark is the one, the enterprise, the company who has used the mark for the very first time in the market, right? But for GI, it all goes to the root of the production, when it has started, and when we have started to provide protection to that. So I think this is two different system, so that, because in certain countries like US, they even consider GI as, in some cases, like Parmesan cheese, as a general term, which is not protectable. So I think there are some other justifications rather than only, I don't know if I got the point correctly, but I think there are some issues relevant to justify, if you want to talk about the main honor, right? The main honor of the GI rights. It goes beyond the use itself. I think what is really appropriate is linking the GI ownership to, but I think even evaluating this would be so difficult if you want to justify who has done what first in the first place. So if you want to consider who registered first, maybe it's easier to justify, but who used it first, it's subject to the evaluation. What do you think, Andrea?
Oh, well, here I think we have two profiles. First of all, the relationship between geographical indications and trademarks or registered trademarks or established by use is usually settled under the domestic legislation. So, for instance, in the European Union, the rule is that after the registration of a geographical indication, basically you can forget about having an identical or similar trademark. But the rule says that if you had already a trademark established, registered or established by using good faith before the registration date, then the two can coexist. And this is one profile, but another profile, and I think this is what really the question was about, is about the cross-border international protection. And this is very tricky, especially even for, let's say, a very heavy stakeholder like the European Union. In fact, the most important EU producers have very efficient, let's say, legal offices that sue people around the world. We had famous cases like Parma ham misused in Canada or in the United States, etc. So the problem is that maybe the foreign country can consider your name generic and so unprotectable, or simply the GI is protected in your jurisdiction but not in another jurisdiction. And the Lisbon Agreement has a very limited membership, and the rules of the TRIPS agreement are extremely vague, so leave member states very free to do many things of what they want. The standard level is an unfair competition level, and then you have wines which enjoy enhanced protection. So what can you do? Sue people around the world. Point number one. Two, try to sign FTAs, so free trade agreements, bilateral agreements. But in that case, you need to have the political weight to do that, or maybe have powerful friends. And this is why the European Union is trying to promote the sui generis system around the world to create a front of protection of these products, even on a bilateral share basis, because a general cross-border protection is out of the question. I think it's very hard to achieve.
Salman, do you have a follow-up question or comment, or can we move to the next question?
I just wanted to take this opportunity to very briefly comment on what Dr. Andrea just said about FTAs. Taking the opportunity of having all of you here, I think, so in case of Pakistan, European Union is one of our biggest trading partners. And the potential for GIs is something that is very, very common between Pakistan, countries like Iran, and European Union. So, I mean, for a country like Pakistan with thousands of years of history and civilization, we have hundreds of GIs that could be, potentially developed, not only protected, but then later commercialized. So I think that brings into question the need for a bilateral agreement between EU and Pakistan. I understand, to my limited knowledge, that probably Pakistan's accession to Geneva Act could be the prerequisite and the necessary force to put that into practice. But I think pending Pakistan's accession to Geneva Act, because I think that would require a lot of preparation, and I think IPO is already doing that, but I think that is in the process. So I think this is something that we need to take up collectively within EU in Pakistan. I mean, we enjoy a very cordial trade relations with the EU. We have a regular grant of a GSP plus status to Pakistan. We will continue to remain an agricultural country for time unseen. So I mean, so just wanted to reinforce what Dr. Andrea said, that probably this is time that we need to look for a bilateral agreement for mutual protection of EU GIs in Pakistan and Pakistani GIs in EU. Thank you.
Perfect. Thank you, Salman. We'll try and finish the session in the next 10 minutes. I skipped one question from Mozambique. He asked, would something as nominal as a street food be open to GI indication given it is specific to the requisite area?
So sorry, the question is if something is considered street food, can you have a GI for that?
As common as street food, can you?
Yes, absolutely. And I think we have several examples. I mean, if you can prove that it's typical of a specific region, the way it is consumed or the way it is produced don't really say. I don't know. We have in Italy a number of traditional like flatbreads or similar stuff, which is traditionally considered street food, and they are all protected. So yeah.
This question prompts
Wes,
me to say.
I would like to add
Yeah,
something.
please go ahead.
Please allow me.
Yeah, sure.
As Dr. Andrea has mentioned, I will just want to add that within these 65 notified GIs of Pakistan, we have Peshawari chapli kebab, and we also have Shikarpuri achar, which were basically produced in the streets or by the street vendors or by the small businesses, and now they qualify for GI registration, or they are GIs of Pakistan. So these are live examples are Mr. Muzammil, that things like this Shikarpuri achar, then Multani son halwa, then Peshawari chapli kebab, then Balochi saji. These are notified GIs of Pakistan, and these were basically years back or decades back. These were street foods. Thank you.
Thank you, Ismail. Thank you. This also reminds me of those who are from Karachi. We have a very interesting street food. It's actually a burger, but it's called ande wala ban kebab, ande wala ban kebab. And anda is egg, and it's a street food, and it's very. I have not eaten that. It's very easy to make. There's a bread, and you put a patty in it, put an egg on it. That's it. That's the food. But I have not eaten the same tasting ande wala ban kebab anywhere in Pakistan. So that would something be. I mean, it's more in the light of the traditional speciality is guaranteed than a specific GI. Um, Sanaz, you wanted to say something.
Yeah, I would like to provide. I had one interesting experience about this protection of recipe, but not under GI, under collective marks in Cambodia. And it was really a very interesting case because the whole, as you mentioned, always, the whole protection idea was for the recipe and the special taste of the Phnom Penh noodle, which is prepared in the capital of Cambodia. Not, for example, the ingredients or the noodle itself or the sauce or spices they are using. The combination of whole as a recipe to be protected as a collective mark. And for this protection, they had all this association of the chefs and everything, and the book of a specification and directive in place to be able to provide protection to the food recipe.
This also, I mean, what Ismail, the examples that Ismail also mentioned. I mean, sometimes I have this kind of, let's say, not a contradiction, but for example, if you say that there has to be a GI, let's say organization, okay, kind of protecting the rights of the people who actually are using that GI. But then I start thinking about these food stuff, like this chapli kebab, which actually is originated from Peshawar, but now it's available everywhere, anywhere that you go in Pakistan. So this the strict GI label for these kind of products, or the food that I mentioned, having a specific link to the geography of that area and reputation and all that, it is usually difficult. And then that's where I start thinking about the European, staggered system of different protections. And I use that example of, for example, the TSG, and that's where I can easily fit these kind of examples as compared to a PDO or a PGI. So it really helps me as a student of GI system to understand the different levels at which these products can be considered as a GI product or a identifier product. Muzammil then asked, is Pakistan a part of WIPO listening system? And Ismail has already answered that not yet, but we are in the process of actually becoming a member. Um, Abdul Bari has asked for how long does GI protection last? So I think Ismail is in Pakistan. He has already mentioned that there's, with regard to the registration, there's no need for renewal. But as a registrant, as a user, you need to keep renewing your user registration or privilege. Um, so Ismail said GI is territorially limited and the owner is government of Pakistan. What if the government decides to protect its GI in other countries? What are measures that is to be taken? Ismail, can you quickly answer that?
Yes, thank you very much, Owais. And thank you very much for the question. It is by Mr. Abdul Bari, I think, yeah?
Yes.
As government has notified registrant bodies are basically owners of these GIs on behalf of the government. When GI is registered locally in Pakistan, then they can proceed everywhere in the world where mostly they have their business or their exports in countries. For example, we have registered basmati rice in Pakistan last year in January, I think. Yes, January 2021. And now we have applied in so many countries where we have our rice exports to other countries. Same is the case with our pink rock salt. Pakistan Mineral Development Corporation is the registered body for that, and being owner of the GI, they can proceed everywhere in the world where they have their exports. Basically, we go towards our export markets or the potential export markets. So, owners of GIs can proceed everywhere after registering their GI locally in Pakistan. IPO Pakistan is responsible only registration of GI in Pakistan. The owners of GIs will have to proceed.
Okay, so what I understand from what you're saying is that a registrant organization can
Yeah.
actually proceed and get it registered elsewhere.
Yeah.
Perfect. We have a question from Vindhya, who is from Sri Lanka. Very interesting question. I really like it. It's very challenging. How law is applied for infringing the registered GI? In case like tea, if GI protected tea is blended with other tea, how they can use the GI status? Very interesting question. Who's going to take it?
Well,
Okay. Oh, and Andrea, go ahead. Go ahead.
well, this is a very technical question. So, for instance, the idea is if I make a tea which is actually a blend of my tea and another tea which is protected by GI, well, what happens? Again, I think this really depends on what your national law says. So, at the moment, for instance, in the European Union, the rule is that you can use the name of another of a GI product which you are using as an ingredient, basically, if that ingredient provides a specific characteristic to your product. So, for instance, we had this case about a guy who started marketing an ice cream aromatized with champagne and called it like champagne sorbet or something like that. And the idea is it's fine because you are informing consumers that that specific GI product is providing a specific feature to your product, to your final product as an ingredient. Now we have a new proposal which is going to have a deep impact. I mean, a proposal to reform the agri-food regulation, which is also going to impact the other EU regulations. The proposal was published on 2 May 2022, but we don't know where it's going to come into force. And they're going to introduce a more straightforward rule, which is you can mention that GI product among your ingredients, but you cannot use it in the name of the product. So in the example made, I can blend the GI tea with my own tea and make it a product. I can list the GI product in the ingredients because it's important to inform consumers, but I cannot use it in the name of my product. So I cannot, free ride on the name of the GI product.
And I would like to add one point to this, going back to the importance of having the GI organization and the control system in place. This is exactly the part that is identified under the book of specification. This is where the controlling over the production is really important, because oftentimes it also happens among the producers, which are already the member of the GI organization, that are also deviating to use the blend or mix the other type of the products to their own products, which is protected under GI system. And unfortunately, in some cases after pandemic, this happened a lot because everyone was at home. There was basically no possibility of having the overall control over the production and also selling, not even the production, the selling phase. So yeah, so this is really important to have different mechanism in place. And I don't know how far Pakistan has gone to establish this after the law and implementing the registration phase.
Perfect. There's one last question, and we are almost finished with the time. Imtiaz is asking a very interesting question. What is the threshold for reputation of any product to determine whether it should be protected under GI at national level and also at international level? Brief reply to that. Oh, it's a challenge to reply briefly to that.
I mean, it's a bit of a challenge. In fact, my book is like 340 pages basically to answer these questions, but in 30 seconds. Well, the international level, I don't think it's very relevant because the Lisbon Agreement doesn't mention reputation. The Geneva Act now does, and let's see how it is applied in practice. And the TRIPS agreement is just very broad minimum standards with no register. But for instance, the reputational element in the EU is usually the fact that you want to prove that your product is linked to a specific place, not because of natural, let's say, features, but because consumers associate that place with a specific product. I think it happens pretty much anywhere in the world. There are cities or areas which are particularly famous for a specific kind of product, and you want to protect this image of the product which is in the mind of consumers. Of course, you can also provide other sorts of evidence. So not just market-related evidence, but also history is often used. The history of the product is often used as an evidence. So you say the market believes that that product comes from that place and not another because this is the history of the last 400 years. It has always been made there. So the big distinction is reputation is more the image of the product on the market. A qualitative link is more about terroir. So you can prove that that product is the way it is because of the specificities of where it is produced. So it's a bit more complex, maybe.
Thank you very much for that answer. This is also quick 10-second answer, 10-second comment. In Pakistan, this reminds me of the time in the last 15 years when I started thinking that in Pakistan it's less of anything else, neither the terroir nor the reputation, but the political muscle that a set of farmers or let's say exporters or operators for a certain product. And in case of basmati, we had a long battle within Pakistan itself, where it was a bit difficult with regard to the question of reputation or with regard to the question of terroir, but more the problem was who actually can own the GI, starting within the country and then going afterwards outside of Pakistan. So I think we don't have any more questions. There's one last one, if I can take this. GI claim can be filed in any international platform. If yes, then what are those platforms? So if a right owner wants to file a claim, is there any international platform, or there's these are to be filed in national courts?
We have only one international platform in place, which is Lisbon. And it's for registration, not for any sort of claim. We don't have any international court to hear the disputes. But as I mentioned, we have WIPO Arbitration and Mediation Center, and also WTO Dispute Settlement Body, because WTO Dispute Settlement Body is in charge of government to government, all these, issues between developing countries and, the debate.
Mostly treaty violations.
Huh?
Treaty violations, or that
Yeah.
too, in this case, TRIPS.
Yeah, for example, the case of traditional knowledge and genetic resources, there is a lot of interaction between GI and these two, and this is why it took ages, more than 2 decades, to have the convention finally in place in WIPO in terms of traditional knowledge and genetic resources. But the registration phase is only Lisbon. For business to business or individuals claims, there is the possibility of going to WIPO Arbitration and Mediation Center, but it is also under development. There are not so many cases in hand at the moment.
Perfect. So that brings us to the conclusion of this webinar. I'm really grateful to all the 3 speakers, and I'm also grateful to Salman Khalid, who joined us from Geneva, representing the Pakistani permanent mission in the UN. And I'm also grateful to all the participants who actually joined us from different parts of the world. I could see that there were participants from so many different countries. And I'm especially thankful to my students who actually joined this webinar and asked some very interesting questions. These students are from the bachelor level, and I'm happy that they could. And it's 9:30 in the evening in Karachi, and they're still sitting. And so I'm grateful to everyone who joined, and others who joined from Pakistan as well. So I'm really grateful to Dr. Zappalaglio, Ms. Farahzadi, Mr. Mohammed Ismail, and all the participants who joined us today. And hopefully we will continue, inshallah, in future as well, webinars on different topics related to IP. And yeah, so I'll be very happy to see you all again in our future webinars as well. So have a very good evening and afternoon, or wherever you are, and we'll see inshallah each other very soon. Okay, thank you very much.
Thank you very much.
Thank you so much. Bye-bye. Bye.
Thank you very much. Bye.